There we go. So welcome to our third mediation breakfast. I'm Roberta Regazzoni and I work for the Arbitration Chamber of Milan, which is a private institution owned by a public one, which is the Milan Chamber of Commerce. We specialize in alternative dispute resolution, and together with Megimo and the law firm De Berti Iacchia have started about 2 years ago this working group on mediation. This third edition is public, is open to the public, while the first two were on invitation only. This time we wanted to go very practical on business mediation, and therefore we expect and welcome your questions and comment very much. I leave the word to my colleague Ekaterina. Thank you.
Hello, my name is Ekaterina Abrosimova. I'm associate professor at Private International Law Department at Megimo University, and I'm extremely happy and honored to welcome everyone here on behalf of Megimo University and our Private International Law Department. It is the third our mediation breakfast so far, and I sincerely hope that our cooperation is going to continue. Now we are facing very hard times, and mediation is extremely important, well, as the way to resolve disputes, because to my mind, it is the only resort to bring conflict to dialogue, not to a dispute, and to continue a legal relationship. That is why practical and scientific cooperation in this sphere is very important. And let me thank everybody here that you joined our conversation and our mediation breakfast. And I have to inform you that we have decided to make this meeting as open as possible. And I have to warn you that the meeting is recorded and is going to be available on YouTube. So if you have any issues about this, please contact the organizers of the meeting, and it's on you to decide whether you want to show your face on YouTube or not, and whether you switch the camera on or off. And well, I personally would ask you to leave the camera on, because the discussion will become more lively if we see your face and your reaction to the practical issues discussed. Thank you very much. Have a very nice meeting.
Perfect. Thank you, Roberta. Thank you, Ekaterina. It's time to introduce myself. I will be moderating this wonderful event. My name is Natalia Gaidayenko-Sher. I'm a lawyer, professional mediator and trainer, member of the panel of mediators at the Russian Chamber of Commerce. So today we have three parts, three systematic parts of our breakfast. First one is about COVID and its impact on the trade. And first, we would like to ask you whether we can already assess the impact of COVID on trade now. So you have a poll. You have 30 seconds to decide whether the time has come or it didn't yet. Okay, perfect.
Okay, here we are. I'm going to share the results of the poll.
Okay, you see 62% of our attendants say that it is too early to assess. Thank you for your opinion. And now, Roberta, tell us about figures.
Yes, I think that they are right, because I wish to add national figures by the Ministry of Justice, but actually, as per dispute resolution in those pandemic times, the ministry only have statistics covering the first 3 months. So it was too early because the pandemic started in Italy on March. But I can tell you something that happened in our institution. For example, I can tell you that nothing has changed as per arbitration cases. We have the same number as last year, 2019. Nothing is COVID related, but I can tell you that arbitration received a boost. Actually, it's not arbitration, but online hearings in arbitration received a boost in those last months. It's a slightly different situation for mediation. In the whole, mediation proceedings have decreased, but this is probably because in Italy, as you probably know, I don't know, mediation is somehow linked with legal actions. So when the government decided to suspend legal proceedings and the work in courts, also cleverly decided to suspend mediation proceedings as well. Anyway, we found out that there was an increase of a particular disputes, classes of disputes, which are lease or rental agreements, meaning the lease or rental of offices, industrial building, warehouses, and homes, of course. Online tools were already well established in our institution as per mediation, because as we have lots of cases, we tried to overcome logistic problem with online dispute resolution. So online mediation was already quite strong at the chamber. So I think that summing up, I can tell you that it is now too early to establish if COVID-19 has been and which impact has been on dispute resolution right now. Thank you.
Thank you very much, Roberta. And now I would like to introduce our first speakers who represent users of mediation. These are businesses who have already experienced the impact of COVID on their trade, and they will share their concerns about the future of the dispute resolution in the area. And I would like to give a word to Mr. Azamat Malkarov, who will introduce his vision of the situation right now. Azamat, hello, you have 10 minutes.
Good morning, everyone. So my name is Azamat Malkarov, and I am a CEO in a Russian-based holding company and a CEO in one of its subsidiaries, which actually took part in the mediation procedure. Well, I will briefly tell you about the case and the way we solved it, and I hope you will find our experience very useful and applicable to your current conditions. I will not consider any legal aspects of the case. So our dispute arose when our supplier and a licensor, a Norway company, a pioneer in its field, terminated the contract due to our breach. And since we made advance payments and didn't get any consideration, we asked our opponent to return the funds. The opponent claimed he suffered damages which must be recovered from the advance payments. Basically, it's a normal situation, but still. We started the dialogue, but couldn't reach any reasonable consensus during a long period of time. We considered many options of solving the dispute, but could not find any reasonable solution to satisfy both parties. That was due to from many complicated aspects of the case and quite a big amount of money involved. So in the end, we decided to use the mediation procedure and the mediators of Russian chambers of commerce made a sufficient effort in solving a dispute. So why it's a burning issue? That was the first mediation procedure we've done. The mediators helped us to find the consensus for those who argue around a subject but can't reach the finish line. That's the first point. The second one, the mediation procedure was online. You know, honestly, an online dispute resolution per se was something new for me and my colleagues who prefer some kind of old school face-to-face meeting and tough negotiations. But that was something new, and that was quite unusual to discuss this kind of questions sitting near laptop or your phone. And by the way, if I'm wrong, that was the first online experience for mediators as well. How we did that? First, we agreed with our opponent to conduct a mediation online. Next, we applied to the Russian Chamber of Commerce, and we had a brief talk to mediators related to technical issues of the case. We made a mediation agreement, paid the mediation fees, and how the mediators work. We applied to all the documents related to the case, so the mediators can have a brief look at them. Each party had conducted private consultations with mediators to discuss the case and its claims. I think the mediators had enough time to scrutinize the documents and related information. And finally, we met online together right now, as we do it right now. We had pretty long-lasting session, long-lasting conversations and discussions, but you know, finally we solved the dispute and we managed to sign the final agreement. We found it very effective in this particular case. We found it very cost, time, and money saving, and we enjoy the process and the outcome as it is. This year we faced the COVID-19, and I think the online meetings are here to stay for a long period of time. So I think the pandemic revealed a new strong step in a new business, but doing business online. That's a huge effort. So thank you. That was my brief talk. Any questions?
Thank you very much, Azamat. I think that after your presentation, you will have questions probably from prospective users. Yes, if they have them, so you may either raise your hands or you may put them into the chat. So should you have ones. Okay. For a time being, we have nothing, and therefore I suggest that Ekaterina Konevskaya-Zapieri tells us about her experiences in these difficult times and dispute resolution issues in her trade. Thank you. You're welcome.
Good morning to everybody. I'm very pleased and honored to participate in this mediation breakfast. Thanks, Roberta, for inviting me. My name is Ekaterina Konevskaya, as Natalia presented me already. I'm born and raised in Russia. I live in Italy since 2000, and to gain some credit as a speaker, I have to underline that I'm married since 2003 and I have a teenage girl, and it means that I have a good capacities in mediation and I practice it on a regular basis by my own. And today I represent a fashion business branch that is taken as something very superficial by most of us, but for Italian economy, it's a very important branch that counts more than 80 billions per year, and it gives a lot of job to many people. So by my opinion, by our opinion, it's a very important sector to protect. So far, we didn't have any help from the government, and we have to deal with the surviving by ourselves, and mediation became very important, let's say, in this period. the role of an agent in the fashion, because the Zapieri Group is one of the oldest agent and distributor in Italy. Our natural role is a mediator between the enterprises that produce the collections and the retailers that do purchase the collections. So it belongs us, let's say, naturally. Unfortunately, very few of us do have a professional, let's say, background in mediation, and unless Azamat, we never used the professional help of mediators, but definitely we could do a good use of it in this period, because since February we are conducting often exhausting negotiations with our partners and with the companies that we do represent, because we are stay right in the middle. We started in early February. A very important partner of us in China asked us for unprecedentedly heavy conditions because the COVID was already devastating the Wuhan province, and the whole economy was suffering. And let's say that our partner asked us to give the conditions that we couldn't afford, but at this moment we were not even having the sensibility towards those this kind of request. We were considering this problem as a very far away from our backyard in a remote part of China, and we were scandalized. We were very, let's say, tough in answering to our partner, and in time of 1 month ourselves we were in lockdown, and we were facing the situation when we were not able to respect our obligations toward our partners. So let's say this COVID situation teaches us that we are very much linked one to each other. I think in the fashion industry, like in many other industries, and we definitely need each other to be in a good health, or at least to stay alive, in order to safeguard the whole chain. Every ring matters, and we cannot lose even one of it. And we have to contribute with the mediation to stay connected. Sorry. Basically, the peculiar aspect of our role, of the agent role, is that the companies that we do represent and our customers are our main asset. We don't have other assets. So for us, the litigation is really the very last step. We are very strongly oriented towards the mediation at each cost. Clearly, we are searching for a win-win solution, the famous win-win solution, but we are, I mean, really, we don't have the professional mediation skills, and we don't master the advanced techniques of mediation, and we would like to have it. I think that for our category, it would be very important to do the mediation courses to, let's say, increase our capacities in the negotiation. More or less, it's all I wanted to say for the moment, and I will be very glad to answer your questions in case you have something to ask. Thank you for your attention.
Thank you very much, Ekaterina, for sharing this experience with us. And Roberta, just take note of the need in sensibilization course for businesses. Just a good thing for, probably we could do it jointly. Why not? It could be a good idea of having such a joint sensibilization course for businesses. So I think that after we have heard the users, the time has come for a second poll. Have you ever thought about mediation as a way to renegotiate a contract, which is particularly good illustrated by Ekaterina?
Okay, it's time to show the results.
Perfect. I did not expect it, really. I know it will not work. There is nobody who thinks about it. So it's very inspiring, I would say. Thank you very much for sharing your optimistic view on this tool. So we have heard the users. Now we go to the most influential part of our audience, the part which influences the users and conducts them through all the dispute resolution procedures. So we go to the lawyers. And we would ask Natalia Kislякова to ask her thoughts about mediation in times of COVID and its probable use. Do you recommend it to your clients? So you're welcome to share.
Thank you very much. It's my pleasure to be participant of this conference, especially because we have a lot of Italian clients and projects related to Russian-Italian relationships, which is not obvious, I think, but strangely, I think somehow our firm is very much related to the Russian-Italian dispute resolution. I think I will speak about three major things. Firstly, as you asked me about mediation, whether we invite parties to mediate and how it is going with mediation. Generally, and especially in this particular period of time. Secondly, I think I share general overview how it's going on the market. As for mediation, I think it's a very nice and perfect tool for dispute resolution, but the main, I think the main difficulty is that psychologically parties tend to think that they are 100% right and the opponent is 100% wrong, and they want just some blood, some decision, and not ready for negotiations. And I think to be ready to mediate, you should be ready to negotiate. But in order to negotiate effectively, you need a third party who would be able to somehow present position in such a way so it's not neglected directly. And one of our Italian colleagues is really good at that. It's in-house counsel, but they often have different construction projects in Moscow and they have some difficulties with subcontractors. And we participate sometimes with the opposing lawyers on telephone calls, and he starts always, I totally understand your position, I totally understand, it's very good, but please consider. And he's very polite, and sometimes with this approach of feeling someone's pain, he achieves a lot in these negotiations. It's not mediation per se, but I would say that it is somehow similar because it has a lot to do with the understanding the position of your opponent. And speaking about the situation on the market, I will say that of course a lot of lease agreements were put in danger, and we have a lot of projects related to lease agreement and not willingness to prolongate it due to lockdown. And strangely, but it's also the case, there are more cases, not that we suffer from the lack of work, but even more cases, but not related to force majeure, as somebody expects, but there are some, I don't know, somebody owes, I don't know, $500,000 already 2.5 years, and everybody thinks, okay, they will pay us later, we don't want to ruin our relationships, we will just wait. But now, as everybody is experiencing crisis, a lot of firms, they just think, oh, I think somebody owed me like $100 or $200. I should file a claim to arbitration, or I should file a claim to a court. So they have some money, and legal entities now, they tend to ruin previous good relationships in order to get this old debt that has been hanging for, I don't know, months and months, and nobody remembered, like 1.5 years, 2 years, it was just somewhere. And now people think like, oh, we should just try to get this money. So that's the tendency that I personally saw, but maybe it's not 100% representative, because we specialize on the middle market. So we don't handle huge cases, we handle pretty middle market cases. That's it. Thank you very much for the invitation.
Thank you very much, Natalia. So you have spoken about the tendencies, so which are rather tough, and about the experience of your colleague who is handling construction disputes. And it's a good approach, of course. I do understand your position, but I think that those who want to claim money now, they say, but you must understand my position. That's the idea. Okay, thank you very much, Natalia. And just in the beginning, Roberta told us that there was tremendous increase of disputes in the lease agreements. So I think that the right person to talk about is Armando Ambrosio. Yes, Armando, you're welcome. You have the floor.
Thank you, Natalia. Try to share the screen with you so that you can see also the slides. Okay, so first of all, thank you to the Arbitration Chamber of Milan and to MGIMO as co-organizers of this event. I'm an international lawyer and mediator, and I normally work between Italy and Russia. As Roberta Regazzoni said at the beginning, there is a tremendous increase of litigation or cases concerning lease agreements. So why I decided to choose this topic? Just for this reason, because it is an hot topic, because it is probably the commercial contract, the lease agreement is probably the commercial contract which is most affected by the coronavirus pandemic. As you can understand, one party owns property, the other party is using the property. Due to the lockdown, the other party cannot use the property. So it is very easy to understand that one party is not fulfilling its obligations for say, justified reason. So the case is there, so it's very clear and straightforward. I will not go too much into detail, but my idea is to go through the legislation of the two countries which I know most, Italy and Russia, and explain you briefly how this legislation have reacted to this problem, what kind of measures they have implemented. But let's say the key point is not to discuss about legal aspects, but how to learn from this experience, how to learn from these problems and what we can. Of course, my perspective is the perspective of a lawyer, but I'm also an international mediator, so we'll take into account also the consideration of mediation. Let's start with how the Russia, which position Russia took concerning lease agreement. Russia, like Italy, they implemented a range of remedies. The first one was the right to postpone the payment of the rent. So this right applies only to a portion of the rent, which was 100% during the lockdown and 50% for the rest of the period until the 1st of October 2020. This postponement right does not apply to utility bills if they are to be paid by the tenant. And the third amount can be paid during a period from 1st of January 2021 up until 1 year later, 1st of January 2023. So 2 years later. The deferral was granted, as I say before, until the 31st of October 2020. Then another remedy is the right to request a rent reduction, but here there is no corresponding obligation on the landlord, so it's just up to negotiation. So you may understand that mediation can play a role in this respect. And finally, there is a potential right to withdraw from the contract, but under very specific conditions. So it's very limited, and it's not a tool which is easily used by all companies. Now let's see the Italian approach to this problem. The provision in Italy were one of tax nature, the other one was, let's say, of civil procedure nature. Italy granted a credit of 60% to the tenant, and this measure applied only to certain type of properties. At the beginning it was just shops, then it was extended to all the non-residential properties. The reference period is just 3 months, more or less. 1 month for one of the measures, so one for shops, and 3 months for the others, which was then extended. And some specific conditions apply to the general cases, such as the revenues of the company should not exceed more than 5 billion euro in the year before, in 2019. And secondly, the other issue was that only one 50% of this measure could be taken into account. So the other remedy was the suspension of enforcement to procedure of release of property, which was extending from time to time up until the 31st of December of this year. So you can see that if you make a comparison between the two approaches, you can see the measures which were implemented by Russia: right to postpone the payment, right to request a rent reduction, limited cases, also the right to withdraw from the contract. So you can see that the Russian approach is a soft intervention which was made by the state in order to adjust some unfair results which were evident in the existing contracts. So basically what Russia did, it gave some guidelines which were given by the state, and indirectly it also set some standards which are useful for the court, because you can understand that more they give the idea, the Russian state, which is supporting a renegotiation of the contracts, especially in those situations which are more, let's say, evident, where the loss is more evident. The Italian approach is completely different. So it's no more left to the parties, it's left to the state. It's the state who intervenes and gives a grant to the tenants. So you can see that there is a tax credit of 60%, which is given to the tenant. And so Italy will just give a financial support by the state and does not give any guidelines to the courts. So that's why I'm not surprised that, as Roberta said, there is a tremendous increase in litigation, because whenever the tax credit is not sufficient, what happens is that you go to court to try to start a case against your counterpart, because you don't feel confident. Approaches have had a completely different consequences also in the impact of these. What are the lessons that we learn from this situation? First of all, that lease has become a very critical area, and it's a source of potential disputes between the parties. This is not just by my thought, but it's just the reality. What happened, especially in Italy, where the legislation was not leaving the autonomy to the parties, but just granting some grant, but without any guideline. So the states have intervened in enacting some special legislation to address the various issues. And you have seen that they've intervened in completely different ways. If you look, it's very strange that Russia has taken a view that the parties are autonomous, that they have to resolve the problem among themselves. In Italy, it's like a socialist state where they give a grant to those who cannot afford to pay. Due to the characteristic of the case, there may be a lot of room, a very large space for the use of mediation. You can understand that in this area, lease agreements, it's very easy to understand that people need the help of mediation if they cannot solve the problem themselves. How many cases were mediated so far? I think very few so far. In our experience, we try to push the parties to mediation in these cases, but most of the time they either wanted to do through negotiation or they prefer to start with court cases. So, but we'll see very much litigation, especially in Italy, for the strange approach which the state has taken. What we can do to foster mediator? Now it's let's say, my position as mediator, which takes the lead in this case. I think that, as it was mentioned before by Ekaterina, we should do a lot of seminars and courses to educate the companies and businessmen to the use of mediation. At the same time, I think that mediators and all the parties involved should make some lobbying in order to convince the state to give a more crucial role to mediation, especially in this situation, in order to avoid that the courts are packed with a lot of new cases. So, a couple of suggestions at the end. The first one for lawyers, in order to avoid any problem in the future, now you've learned the lesson, you should draft a coronavirus clause, not just the usual standard, already packed force majeure, but you should be very careful about what you write, what are the consequences, what are the events, and so on. Be very careful to work out this clause. And as far as businessmen are concerned, I think that when there is a dispute concerning a lease agreement, you should definitely consider mediation. So that's the, let's say, the end result of my talk. And so thank you very much. I leave the floor back to Natalia.
Interactive talk, and so very inspiring and I fully agree with your suggestions. And if you have a look at our chat, we have a very intense discussion on the change of standards of teaching mediation. Since we have time, you are very economic. Thank you very much, our speakers. So before we proceed to the exchange of views by our mediators, I suggest that we discuss a bit the question that Natalia Golovina asked us at the beginning. She actually asked us, should we change the training process for mediators, taking into account the experience we already have due to COVID impacts on trade and ADR in general? So here we have the intense exchange. So, and we come here to the conclusion that that we need to adapt our training to the online reality in which we all exist now. And therefore we must pay more attention to teaching negotiation or mediation online, how to approach it, how to handle it, what should we do.
Sorry, can I?
Of course, Robert.
Can I just, since at the very beginning I said I would like that this forum could be more and more practical. So I ask Azamat, it's a question for you. So I would like to know if before your experience in online mediation, you also experienced traditional mediation.
No, that was my first mediation experience, and it was online. You know, when I did a master degree, we made some kind of mediation workshop and other various alternative dispute resolution things, but in real life, yeah, it was the first mediation experience.
Thank you, Azomat. Because I wanted to ask him if he noticed a difference. I know that our friend Carlo Mosca is probably thinking, because yesterday when we meet for a preparatory meeting, he said online mediation. I don't want to ruin his presentation now, but I believe, since I'm in online mediation since 2001, because the Milan Chamber of Arbitration has an online mediation service since, 20 years ago. And I remember that there were a debate, a very lively debate inside the chamber between two thoughts, two different views on mediation and online mediation. Somebody also told that online mediation cannot be considered real mediation. I think that what Azamat said before, I think there's no difference between the two. I know from a theoretical point of view, especially from the side of the mediator, there is this difference. But since we want to go to the users, for the user, especially if they have always mediated online, it's okay. That's it. Sorry.
Can I argue with you? I think there is a difference. Sorry. I would tell this way. I had an online judicial session during pandemic for several times. So that's the same. You see a judge on your screen. Yeah, you show him your ID, and there is a difference because related to a normal trial, an online trial, let's say there is a difference because when you sit in the one room and you see your opponent and the judge and all these chemistry over there, I think you think different, and you can argue more. You can see the person's reaction, his personal reaction, and act respectively. When you see a person on the video screen on your laptop, that's quite different, and you don't feel his reaction. I mean, judge. You can see clearly his face. You can see his actions. That's quite different and maybe more complicated.
Okay.
Thank you.
Thank you.
Perfect. Thank you very much for sharing this. Is there anybody else who would like to say a final word on it? Yes, Stefano, you're welcome.
Yeah, good morning to everybody. I'm Stefano Pavletic, speaking from Milan. I'm a mediator and chartered accountant. Getting back to our to the invitation coming from our moderator, so to say something about the chat we exchanged about the changing standards in training. Really, I think that's quite an interesting and intriguing point, because I do think that something is going to change also in training within a COVID-19 scenario. For example, I think that we are going to train our fellow professionals or younger or students or newcomers in the mediation world to a different style in mediation. I think our style is going to change, and I remember what we said and we wrote in 2009, 2010, after the big and harsh economic crisis, and something similar happened then. And so I think that our style is going to be, how can I say, less creative mainly, so focusing most in the procedural aspects and the process more than in our creative contribution. Competence is going to be much more important than in the past, because our parties in this COVID scenario are likely to require more competent mediators than in the past. And I also think that's one of the key words in our activity in this strange atmosphere, in this strange extraordinary scenario, is control. So I think that the mediators are going to, let's say, control the process much more than in the past, and having to do with different parties than in the past. So parties, mostly company people, which are likely to be weaker, with less capacity to negotiate, to foresee the future, so to see what's going to happen in the future due to all the uncertainty that has been brought now with this dramatic pandemic. So we have to think that our style is going to change very much in the near future. I don't know if anybody agrees with this, my opinion.
Thank you very much, Stefano, for sharing your view on the subject. And I think that life will show us how it will develop, but I trust that mediation will be more procedural, more technical, and probably more directive. So for directive, I'm always, I think that it can be a very good thing, especially in business mediation, but it's my personal opinion, since I have come to mediation from arbitration, and I have never left arbitration. That's why I have a kind of directive style, but it's another.
We can say that there's a bright future for the evaluative mediators in the years to come, I think.
Yes. Okay. Yes. Right, you are, Natalia. That's technical defaults may make the procedure much less predictable. That's true. So that's, they have the third party in actually the fourth, yes, in our mediation. We don't have only parties, mediator. We have already technical support, and this technical support is not so perfect, so it may, of course, have some impact on mediation itself. That's why we must provide for additional opportunities, for example, to, as we usually do, to switch to the phones. In this case, we don't see the opponent. We may only hear him, but sometimes it's even better when you can see and hear him, because you feel these subtleties in the tone, etc. But this is also the change of standards of teaching. Okay, thank you very much for this. I think that we shall go to the third poll now. Would you add a mediation clause to your contracts? Okay, perfect. So I could not expect another answer from this audience, actually. That's very positive. Okay, so we have heard the users, we have heard the lawyers, we have discussed the coming standards, the change of standards, and now we go to our providers. And I give the floor to Ekaterina Smolyannikova, who will share her experience. So, and she has just recovered, is just recovering from COVID. So just good health, Katya. So you're welcome. You have the floor.
Thank you. Thank you. Thank you for inviting and for this interesting session and for your opinions. Talking about online mediation, my experience with it, I would say that for me as mediator, this is online mediation is better than nothing. I wouldn't call it a proper alternative for live mediation. we're forced to deal with the online mediation. And when I do it, it reminds me of the online art fairs or art exhibitions, when you can see the image, but you don't feel it. When you see a picture or a painting alive, you feel the vibes, you feel the emotions, the tension, the atmosphere. And when you see it as just on the screen, it is just an image and that's it. It doesn't have any influence on you. You don't feel attached to it. So for me, online sessions is a lot the same. I totally agree that we should include the online trainings for future mediators, but it should be another aspect of mediation. We should not see it as a possibility to switch more to online format because it doesn't work, well, as I experience it. I do have some mediations that have started as online before the COVID, and they are still online in online format. But I try to mix them. So I have, for example, a mediation with parties in different countries and in different cities and different towns. So sometimes I travel to them because I cannot keep them totally online. Even during the COVID period,
You have disappeared.
that I,
Okay.
yeah, I'm here. But when I feel that the party is disappearing from the process, so it loses interest, it loses contact, then I choose to travel and to keep it live. So the online format helps a lot, because if we haven't had it, we would lose all possible mediations since March. And everything possible, it goes for everything, like teaching and mediating and meeting friends and everything. But it cannot be the a proper alternative from my perspective. It can be an instrument that we can use in some circumstances. Well, I choose to mix it with, even in these difficult times, blending it with live sessions. This is my experience.
Thank you very much, Ekaterina. So you see, in the chat you have comments. Yes, online mediation is better than nothing. Yes, that's true. And the blended format, that's the ideal solution under the circumstances, actually. So we have no other choice. So,
yes.
And of course, you cannot feel the other party, even if you have perfect camera and perfect equipment here. So that's you have an image and you don't have a person in front of you. Just like
sometimes it is so important to be connected with the party, to see the instant reaction, and then it is it is a possibility for the party to disconnect, and then you don't see it.
Yes.
For example, not answering an email instantly, or switching on the camera, or disconnecting from the session, and then you lose a lot.
Yes, that's the issue. So thank you very much for sharing this with us. And so I believe that Carlo Mosca will tell his experiences that he named yesterday during our preparatory meeting. Online mediation is a nightmare. Carlo, you are welcome to share.
Thank you.
Yes, thank you. Thank you. I'm very glad to be here with you. Thanks to Roberta for inviting me, and I'm very glad to have met you all. Last night I was thinking about what to say and recap my experience concerning online mediation, and I came to the conclusion that there are 4 points, in my view, to be considered, and I'm happy to tell you. Just to give a hint, since last March, I had some 20 mediation sessions, half and half in presence and half in online, both international and domestic. So the good part of all these is that online mediation is great for people living far away, of course. If I have to mediate between a Russian businessman and an Italian one, that's great, of course. And possibly is also safe in this time of social distancing. But having said that, the positive aspects are ended, I suspect, because there are some problems, as have already been mentioned. As Katerina just said, online mediation seems to be better than nothing. And I agree, basically. Anyway, coming to the 4 points. First point, the remotedness. Everybody is far away from the other participants, and these, of course, good senses in a way. Let apart smell and taste, that I suspect are not that important in mediation. Of course, there is sight and hearing and everything. In a way, the idea, the feeling is that there is less feeling, less sense of presence. This is, of course, between mediator and the parties, but also between the parties themselves. And so it's a general sense of more detachment from the situation. That's inevitable. It's better than nothing, okay, again. The second point is what I call the two-dimension orthogonal experience. That means that everybody is looking straight forward. And there is no possibility, or very, very little possibility, that somebody took in another direction. So as a result, nobody talked to each other, but everybody talking in front of them. And that's a strange experience. And so there is we are losing a lot, of course. Everybody can understand what I'm thinking of. Still in this vein of two-dimension experience, I notice also that when I have an assistant with me, or rather an observer, he or she is put in the screen at the same level than any other person. That's somehow strange, because in the real situation, in a present mediation, the observer is like a fly on the wall, is somebody that people don't perceive as present. On the contrary, in online mediation, in Zoom, for example, is just one face among the others. And that's not good in most of the cases. Third point, the audio-video limitation. I experience a lot of mic malfunctioning. There are a lot of old computers that are unidirectional. So if somebody stay a bit in a side of the screen, you can't hear it simply. And in my experience, there are a lot of situations where a lawyer, a counsel, is in the same room with his clients. And so there could be 2 or 3 or 5 people. And so everybody tried to be stuck in the same screen, but inevitably the lawyer talked like that. And so a lot of audio problems in that way. And again, there is a loss of a sense of a room. There is no room any longer. That's a problem. Maybe a problem. But, final fourth point. Does it all may impact according to the kind of approach that the mediators may adopt? In other words, are a facilitative mediators more facilitative than a transformative one or an evaluative one? I have no answer yet, but I suspect that there is no actual difference. I suspect, even though I suspect also that possibly a facilitative mediator could be more in difficulty than a transformative one. And I'll tell you why. Well, a transformative mediator, as I am, as his aim in supporting in a non-directive way the parties' effort to have a meaningful and productive conversation instead of resentful and destructive confrontation. That's in essence. So you facilitate the dialogue in order to transform the quality of the interaction. Doing so, you are acting in the here and now perspective. And in online mediation, according to what we just said, certainly could the here and now possibilities to intervene. But on the other hand, it is all we got. And so we have still the possibility to intervene here and now. Okay. The facilitative mediator instead has to arrange things in order to have the party driven in a way to acceptable terms of settlement. So he actively orchestrates things in order to things to happen. And so I suspect that he could face more difficulties in doing that in an online setting. Take it, for example, the breakout rooms. It's not that easy to utilize that. Yes, of course, it is extremely easy to select breakout rooms and to redirect people there. But it is something different than do it in reality. Me, for example, in mediation, I rarely used to separate people, and so I don't need breakout rooms as Zoom offers. So coming to the end, in my experience, I don't know why, but a good 2/3 of the people who I met in an online mediation asked for a subsequent in-presence session. So that could be an indication that the people, the clients themselves, are not at ease in doing this conversation online. So it's better than nothing, as Katerina rightly said. Thanks.
Thank you very much, Carlo, for your so impressive speech. Okay, fine. That's the illustration to what you have told us. Okay, actually, what we have discussed today, and with the polls, so I don't think that the fourth poll we have prepared is needed, because you have already answered that you consider mediation as a kind of tool to prevent conflicts, and there is no sense of adding something else. So anyway, all the participants so consider mediation as a useful tool in these difficult times. First of all, because it helps to reduce the costs and it allows to stay in contact. And with all this limitation, with this limited possibilities to have a side view of the room, etc., to feel the person, it's better than nothing, and we may develop our skills in order to accommodate them to the existing technical possibilities and solutions. What we have heard today is that our businesses need to learn more about mediation and maybe learn more about online negotiation skills. And we are here, colleagues, mediators, trainers, in order to work on our standards and probably think about joint sensibilization programs for our businesses, the businesses of our countries. So we have heard a lot about different styles in mediation and have come to the conclusion that blended sessions and the idea of people of coming together, meeting physically, remains here, and we shall not struggle with it. And we hope that we shall have an opportunity to see you not only as images on the screen, but physically. And while waiting for these times, we should adapt our practices, our services, and we shall think about doing something which could be helpful for our businesses, helpful to accommodate their needs in a quick, operative, and good dispute resolution. So actually, we have discussed all the issues we had on the agenda. I thank you very much, all the speakers. Thank you very much, the participants of the chat. And should you have any proposals as to our forthcoming mediation breakfast, please send them to organizers so that we could select the theme which is interesting for you. I also suggest you to think about the format of such intervention. That's the first time that we used the polls. Probably you would like to have a battle among those who think that online mediation is okay and others who think that online mediation is a nightmare. Probably you prefer to have a battle here. You're welcome to be creative on the solution to suggest that. And those who are willing to have some memory of our today's meeting, please write to the organizers. You will be provided with a very beautiful certificate. Thank you very much for your attendance. Thank you for your attention, for your participants, for your activity. Thanks, Roberta, for organizing this. Thanks, Gimo, I am alumni of this wonderful university too, for organizing all these. And it was wonderful to see your faces.
Online.
Online,
Thank you.
yet online. Thank you very much.
Thank you to everybody. Bye. Keep in touch.